In everyday life, we buy and sell more than we realize. But behind these simple acts are legal rules that protect both buyer and seller. In this video, we'll break down Articles 1582 to 1593 of the Philippine Civil Code, the heart of the law on the obligations of the parties in a contract of sale. Let's dive into what the law says and what it means for you.
The vendee is simply the buyer in a contract of sale. According to the provision of Article 1582, Chapter 5 on Law and Contract, the vendee has two main obligations. Number one, the vendee must accept the delivery of the things sold. Second, the vendee must pay the price at the time and place that were agreed upon in the contract. However, if no specific time and place were agreed on, then the default rule would be the payment must be made at the same time and same place as the delivery of the thing is sold. Example, if I agree to buy a flower from my classmates, but we didn't say exactly when and where should I pay, then the payment is when she delivers the flower to me, then I must be ready to pay her right there and then. According to the provision of Article 1583, unless otherwise agreed upon, the buyer is not obligated to accept the goods by installments, meaning, if the seller delivers the goods little by little, the buyer have the right to refuse. Now, if the delivery is made by installments, whether the seller makes a defective delivery or the buyer without valid reason refuses to pay, you still need to take into considerations the terms of contract and the circumstances of the case, because breaching does not automatically cancel the whole contract. If the breach is material or would greatly affect the contract, the injured party may refuse to continue and sue for the damages. But if the breach is minor, therefore the injured party may claim damages and must still continue the rest of the contract. Example, you buy a 100 sack of rice to be delivered in 5 installments of 20 sack of rice each. The first delivery is 20 sacks of rice, but the second only is 15 sack of rice and the 5 sack was defective. You may terminate the agreement and file a claim for damages if the defective is severe enough to interfere with the contract's intent. However, you might only request compensation without terminating the whole contract if it's a minor issue that can be resolved.
Hi, I'm Crysnel, and now we're going to talk about Article 1584 of the Civil Code of the Philippines. So first, let's define what does Article 1584 means. So, Article 1584 of the Civil Code of the Philippines pertains to the contract of sales, specifically deals with payment and delivery. Article 1584 states that unless otherwise agreed, the buyer is not bound to accept any deliveries thereof by installments. So, let me give an example in this article. So, Marco bought 50 pieces of laptop from Light Company. So, it is under installment. So, during the third delivery of laptop, he detected 6 units of iPad that is defective, which gives him the right, or which made him think to refuse for the fourth delivery. So, meaning that action of him was justifiable since it is protected or it is under the Article Code 1584 of the Philippines. So, to, to generalize, um, Article 1584 addresses the buyer's right to the product to examine it first before acceptance. It states that if the goods are delivered to a buyer without a prior examination, then the goods is still not accepted until the buyer has the right or has given the right to examine it, then proceed to the acceptance of contract. So the thing here is that this article both protects the buyer and the sellers, which made them think to do seriousness in terms of contract and breach. Because in contracts, there's always a valid reason, there's always a thing that should be addressed if ever that occurrence may occur. There is a valid and there is also invalid happenings that may happen. So the context or the whole context itself should be performed in every scenario. So in that case, it can be dealt by Article 1584 of the Philippines. So the thing in this article is that no obligation should be no thing or obligation should be accepted until it was examined. So now let's proceed to Article 1585 of the Civil Codes. So Article 1585 of the Civil Code of the Philippines outlines the ways in which the buyer is deemed to have accepted the goods that has been delivered to them. So these articles also includes the communication of buyer, which expresses his acceptance already to the seller's delivered goods. So this article may also includes the unreasonable rejection, or the time that the buyer rejects or return the product in a not reasonable time. So for example, um, Lena ordered 50 pieces of lipstick from Macau company. So Lena already accepted the Macau company and she already resells it in a cheaper way or in a cheaper price. So after reselling those things, so returning it to Macau company is no longer valid since she already show shows signs that she already accepted the goods. So meaning you cannot just return the product easily just because you want it. Not unless there is something that should be changed or there is something that is not being fulfilled by the seller. But in that case, that is very impossible since you as a buyer already accepted the goods. So meaning you're already in a good terms, di ba? So yeah, in this article, this protects the seller's right as usual since you cannot just return the product that you have bought since you already show your acceptance. So meaning you claimed the product already. So this article is the point of view of seller. Unlike Article 1585, 84, which is somewhat the POV or the point of view of buyer. So that's the difference between them. So that two article intersects within each other.
Article 1586, this is about if acceptance is not a waiver. When a buyer accepts the goods, meaning he receives and takes ownership, it doesn't mean that he is waiving his right to complain about defects or broken promises. Acceptance here is simply a transfer of possession and ownership. It does not mean that the buyer is saying all is well and I release you from all liability. So even after the buyer accepts the goods, the seller can still be held liable if he breached a promise or warranty. Examples include selling a defect item or not delivering what was agreed upon the contract. The buyer can demand damages or even rescind the sale if justifiable. However, there's a catch. The buyer must inform the seller of the defect within a reasonable time. This time starts not only when the buyer actually finds out about the defect, but also from when he should have known had he checked properly. The rule focuses the buyer to act promptly. Why? To protect the seller from the claims that make it hard for him to investigate and fix the problem. If the buyer if the buyer delays too much without notice, the seller is no longer valid or no longer liable to that particular defects. So now let's focus about the Article 1587, and it's all about the buyer's rights and duties when he rightfully refuses the goods. So number one, rightful refusal and buyer's limited duty. So if a buyer is sent goods and he has a valid reason to reject them, say that the wrong items or defective products, the law says he's not required to go out of his way to return them. All he must do is notify the seller of his refusal in legal terms. He becomes the bailee. It's like someone who holds things for someone else, but only because the goods were forced upon him. His only duty is to take responsible care of the goods while they're in his possession, but he doesn't have to return them himself. So, number two, it is about the seller must take back the goods once the buyer notified them. So, gives the notice of refusal, the burden shifts to the seller. It is now the seller's job to come and take back the goods. So, this ensures fairness to the buyer because the buyer protected from extra hassle when he's not at fault. Now let's go to number three. Risk stays with the seller. If the goods get damaged or lost while sitting with the buyer after rightful refusal, the loss falls on the seller. Why? Because legally, the risk stays with the seller. Unless the buyer voluntarily accepts responsibility, it becomes a depositary. So number four, buyer's right to resell. If the seller fails to act, if the seller doesn't show up in retrieving the goods even after being notified, the buyer can eventually resell them. The rules on seller resell under Article 1533 generally apply, meaning the buyer can recover his expenses and the rest gone is to the seller. So that's all about Article 1587.
Let's talk about Article 1588. This provision is all about what happens when a buyer says no thanks to the goods that the seller has already sent, but don't have a valid reason for refusing. Here's the deal. If the contract doesn't says otherwise, and the buyer refuses the goods without just a cause, the law will treat it as if the buyer already owns them once the goods are made available. Basically, once they are ready for pickup or delivered to the buyer's location. Even if the buyer says, I don't want it, the ownership and risk will pass to them anyways. Think of it like someone shipping you a package. If he refuses it without a good reason, it doesn't matter. The law sees it as yours from the moment it arrives. For example, let's say the seller ships a machine to a buyer through LBC. The buyer refuses to accept it in his warehouse without a good reason, maybe just change his or her mind. Under Article 1588, the buyer still will be the owner of the machine when it reaches its warehouse. They can just walk away from their obligation. Now we will look at Article 1589. This article is about interest, specifically when and why a buyers need to pay interest on the purchase price of goods. There are three main situations wherein the interest becomes the buyer's responsibility. First, if the buyers and seller agreed on interest. Second, if the goods themselves produces income, like rent or profit. Third, if the buyer delays payment after being asked. For example, seller sells a house that the buyer rent out for profit. The buyer delay payments. Even though the payment deadline has not yet passed, Even though there is no demand letter yet, the buyer has obligation to pay interest because they're already making money from the house.
So now let's move on and talk about Article 1590 of the Civil Code, which addresses a very practical and protective rights given to the vendees in a contract of sales. In any sales, a buyer is expected to pay the price, and a seller is expected to deliver the sold thing. However, there are some situations where the buyer may be at risk, especially when the right to the thing is under threat. Article 1590 states that a vendee may suspend the payment of the price in these two cases, either of these two cases. So first, when the vendee is disturbed in the possession of the bought thing, this refers to the actual legal disturbance. Second, when the vendee has a well-founded fear that a disturbance will occur. This means even if there is no case yet or there is no case filed yet, if there is a risk or serious risk that a legal claims will occur, like the foreclosure of the mortgage threatening a buyer's ownership, the vendee may suspend the payment. It is important because it prevents the buyer from paying something that could ultimately lose. However, this right is not absolute and there are some limitations. Meanwhile, there are clear exceptions where the buyer cannot suspend the payment. First, when the seller gives a security, like a guarantee that the payment or the price will be returned once the disturbance proves valid. Second, if there is a stipulation in the contract stating or requiring that the buyer should pay even if there is a disturbance. Third, if the vendors have already resolved the issue, meaning the claim has been already addressed. Fourth, if the disturbance is merely an act of trespass, like someone entering a property without a legal claim, this is not a sufficient reason or to be just justifiable just to suspend the payment. And lastly, if the buyer already fully paid the price and taken the possession of the property, the sale is considered terminated and this article no longer applies. So in short, Article 1590 strikes a balance between protecting the buyer from unjust loss and preventing them from using baseless fear to avoid payment. It also recognizes that ownership, it's not just about having the right in hand, but it's also about having the peace of mind that your right to the thing is secured. So now let's have an example. Russell buys a house from Andre worth 4 million. She pays 1 million as a down payment and agrees to pay the remaining 3 million in 2 installments. After moving in, Russell received a court notice to another person named Alexa, who filed a vindicatory action, claiming that she is the rightful owner of the house and presenting an old title under her name. So what could be the possible solution? Since now, Russell facing a legal challenge to her ownership through a vindicatory action, Russell can suspend the payment of the remaining 3 million until Andre resolves the legal issue or provides security to return the money if in case Russell loses the property. This protects Russell from taking risks of paying the full amount of the property that she may not be able to keep. Additionally, it is not a merely trespass, so Russell cannot suspend the payment since the reason is not justifiable. Next, I'll be discussing Article 1591 of the Civil Code, which grants the vendor a special right of rescission in sales of immovable property. This provision applies on real estate such as land or building, and only applies in situation where the vendor faces a serious risk of losing both the property and the price. So let's elaborate. This article comes into play when the property has already been delivered to the buyer, but the price has not yet been paid. If the vendor has a reasonable ground to fear that the property is being destroyed or misused, and simultaneously the buyer may never pay, then the vendor may promptly file for rescission of the sale. For instance, demanding of payment would be incapable. But the law protects the vendor by allowing rescission, which means canceling the contract or recovering the property before it's too late. However, if there is no urgent risk or either in the property or the price, then Article 1191 applies instead. This allows the seller to choose whether fulfillment or rescission, but only in cases of substantial breach. So let's have an example. Andrew sold a piece of land to Jess. The sale was agreed upon with a down payment and the remaining balance was due at 6 months. After the possession of the land, Jessie started to remove valuable trees and destroying parts of land for his work site. Of course, Andrew became concerned since Jess is not paying the remaining balance and he knew that Jess has or had recently filed for bankruptcy. So what could be the possible action for Andrew's case? Since Andrew has a reasonable ground to fear the loss of both the property and the price, since Jess is not paying the remaining balance and facing an insolvency, Andrew can immediately sue for rescission because there is a destruction of the property and Jess is facing a financial instability, making it a risk to lose both the property and the substantial payment. So rescission is the best remedy.
Article 1592. Rescission of sale of immovable property. What it is about. This article talks about what happens when someone buys a piece of land or immovable property and doesn't pay the agreed price in time. So in this article, we have things to consider. The first one is automatic rescission. Sometimes a sale agreement might say that if the buyer doesn't pay on time, the sale is automatically cancelled or rescinded. The second one is vendor's right. Even if there's a clause about automatic rescission, the seller or the vendor still needs to officially demand rescission, either through a court or judicially, or a notary public. This is important to make it clear that they want to cancel the sale. The third one is buyer's chance. Before the seller makes this official demand, the buyer still has the chance to pay the price, even the deadline has passed. For example, imagine you buy a house but don't pay the full price by the agreed date. The contract says that if you don't pay, the sale is automatically cancelled. However, the seller still needs to officially tell you they want to cancel the sale before it actually happens. You still have a chance to pay the price before that official demand is made. Let's proceed to the next article. Article 1593. Rescission of sale of movable property. What it is about. This article covers what happens when someone buys something that can be moved or movable property and doesn't pay or accept delivery on time. So in this article, we also have things to consider. The first one is automatic rescission. If the buyer doesn't pick up the item or pay the price by the agreed date, unless a longer payment period was agreed upon, the sale is automatically cancelled. This is different from immovable property or land, where the seller needs to make an official demand. The second one is no valid cause. The buyer must have a good reason for not paying or accepting delivery. Otherwise, the sale is automatically cancelled. For example, let's say you buy a guitar and it is supposed to be delivered on May 15th. If you don't pick up or pay the price by that date and you don't have a good excuse, the sale is automatically cancelled. So there are key differences between Articles 1592 and 1593. The first thing is official demand. For land, the seller needs to make an official demand for recession. For movable goods, the sale is cancelled automatically if the buyer doesn't pay or accept delivery on time. The second difference is stable prices. The reason for this difference is that land prices tend to be more stable than the price of the other things that can be moved, because the price of movable goods can change quickly. The seller needs more protection from losses.
Understanding the law is the first step to protecting your rights and making informed decisions. Thank you for watching. And remember, the law is here to guide, not to confuse.